Good morning, good afternoon, or good evening. No matter where your day finds you, welcome to Competency 4 of 5. Explore state and local alcohol related laws, ordinances, and regulations. Presented to you today by rvslearn.com, a nonprofit volunteer organization. The learning objectives associated with competency number 4 are as follows. Explore alcohol regulations, licensing, and the relationship to state and local control. Determine the legal requirements to be a licensed operator. Examine the consequences to the individual, business/organization for failing to comply with state laws. And lastly, navigate the laws regarding minimum legal drinking age, exceptions, and the limitations in Wisconsin. To begin our discussion today, we want to talk about the three basic types of alcohol licenses that are issued by the state of Wisconsin through local municipalities. Class A, sale for consumption off premises, beer only, liquor only, or both, like a liquor store. Class B, sale for consumption on or off the premises, a bar, a restaurant. And Class C, wine only sales, a little unusual, but they are issued. Licensing, just the facts. A license is a privilege granted by a municipality. It is not a right. State law allows for inspection of licensed premises during all reasonable hours. A license can be issued to an individual, partnership, corporation, or limited liability company. A municipality can deny any entity a license for any reason not considered discriminatory or arbitrary. State application process must be followed, but municipalities can add additional steps. Now let's discuss the legal requirements to be a licensed operator or server. An individual must have achieved 18 years of age or greater. An individual must not have been arrested or convicted in regards to an activity that substantially relates to the licensed activity. This could be an OWI. An individual must have proof of successfully completing a state-approved responsible beverage server course, like we're taking now. An individual must complete the process to obtain the appropriate license in the municipality they plan to work. Each municipality will issue a license based on completion of this course and the above requirements. If you work in two different cities or municipalities, you will need two different licenses. There is a fee, and part of that fee is used to do a background check on yourself or any individual. Some more facts. Not everyone bartending or working as a clerk needs a license in Wisconsin. This is true. Not every server on the establishment needs to have a license, but at least one does. And in most cases, most organizations have gone to enforcing the fact that everyone should have a license. Individuals must apply for an operator's license for every municipality they plan to work. If you work in two cities, you'll need two licenses. Municipalities may establish specific additional criteria for operators, but they cannot conflict with state law. A business that has a license to sell alcohol on its premises cannot open for business without the presence of a licensed operator. It's true. A responsible beverage server must have an operator's license or be under the immediate visual supervision of a licensed operator to serve or sell alcohol in the state of Wisconsin. We spoke about this earlier. Remember, in the establishment, the person with the license must be able to visually see the others that are working without the license. Background checks when applying for an operator license are very common. It's very true. No matter what municipality you apply for a license for, when you take your certificate of completion for this course, they will charge you a fee, have you fill out an application form and complete a background check. They will then issue the license so many days later. Examine the consequences to the individual and business / organization for failing to comply with local and state laws. All responsible beverage servers must refuse to serve or sell alcohol to any individual who is clearly intoxicated, or he or she can be fined up to $500 and or be sent to jail for up to 60 days. Responsible beverage servers could be sued by a third party harmed by an intoxicated customer. It's true. If you serve an intoxicated person and they go out and get in an accident and harm a third party, you can be held responsible. Responsible beverage servers who do not follow the laws put their customers in danger of OWI, or operating while intoxicated. Individuals found to be operating a vehicle with a blood alcohol content, BAC, of 0.08% or greater are considered intoxicated and will be fined, lose their license for a period of time, and possible required classes and or alcohol assessment. Businesses could lose their liquor license if local municipalities informed of or discovers violations. Could be sued by a third party harmed by an intoxicated customer. Risk creating a violator's reputation in the community, government, and law enforcement. The way we treat intoxicated individuals reflects on the reputation of the establishment. Social hosts and dram shop liability. Wisconsin Statute Section 1.125.035. A person is immune from civil liability, meaning being sued, arising out of the act of procuring alcohol beverages for or selling or dispensing or giving away alcohol beverages to another person. Dram shop, referring to alcohol sold by a licensed party. The term dram comes from a unit of measurement used in the past when selling alcohol. So we are a dram shop state. So let's take a look. Social host, referring to an alcohol served to a guest. There are three parties involved in this discussion. The first party, the server, you, and licensee. Second party, the intoxicated customer. And third party, the individual who is harmed. In the state of Wisconsin, the primary goal of third-party liability is to make it very clear to every server and licensee that it is their responsibility to obey all liquor laws, and if not, they will be held liable. Responsible beverage servers who follow the laws are rarely, if ever, held liable in the state of Wisconsin. To summarize, if you serve an intoxicated person, if you serve an underage person, and they go out and get in an accident and harm a third party, you will be held liable civilly and criminally. So basically, follow the laws, know the laws, and you should be fined. Navigating the laws regarding minimum legal drinking age, exceptions, and the limitations in Wisconsin. What is the legal drinking age in Wisconsin? 21 years of age. This is also the age at which a person can be on a licensed premises. There are some exceptions which we will discuss below. Can children be in the bar with their parents? Yes. Persons under the age of 21 may be on a licensed premises if they are with their parents, guardians, or spouses of legal drinking age. But this is at the discretion of the licensee business. Can an underage person possess and consume alcohol beverages on a licensed premises? Yes. Persons under age 21 may possess and consume alcohol beverages if they are with their parents, guardians, or spouses of legal drinking age. But this is at the discretion of the licensee. The licensed premise may choose to prohibit consumption and possession of alcohol beverages by underage persons. Are there other times that underage persons can be on a licensed premises? Yes, there are several. Please see publication 302, Wisconsin Alcohol Beverage Tobacco Laws for Retailers, for more information. I've heard of have to break empty liquor bottles. What if I recycle? You do not need to break empty intoxicating liquor bottles, but you must scratch or deface or mutilate the label so that it cannot be used again. If you recycle, empty liquor bottles must be stored in containers marked for recycling only and must be removed from the premises within 10 days. The rule about defacing labels does not apply to ceramic commemorative bottles and other uniquely designed containers. Can I refill empty bottles? No, this is illegal. You cannot refill bottles, even if the same brand of liquor is used. When can officers and agents inspect the premises? The law says they can inspect at all reasonable hours. This means the hours when the place is open for business and other hours if the place is open, operating, or occupied. Can't I buy small amounts of beer, wine, and liquor or cigarettes and tobacco products from other retailers to resell? There is no exceptions for small amounts. Any alcohol purchased in violation is subject to seizure. The information comes from the State of Wisconsin Department of Revenue. If you want more information, you can see the website there. Challenge question 1, true or false? A license is a privilege granted by the municipality. True or false? If you said true, you are correct. It is not a right. Challenge question 2, true or false? A business that has a license to sell alcohol on its premises cannot open for business without the premises of a licensed operator. True or false? If you said true, you are correct. Good job. Challenge question 3, multiple choice this time. Which of the following are requirements to be a licensed operator? Must be at least 18 years old, pass a background check, complete an RBS course, all of the above. If you chose all of the above, you are correct. Good job. Lastly, another true and false. Challenge question 4. In the state of Wisconsin, the primary goal of third-party liability is to make it very clear to every server and licensee that it is their responsibility to obey all liquor laws, and if not, they will be held liable. Responsible beverage servers who follow the laws are rarely, if ever, held liable in the state of Wisconsin. True or false? If you said true, you are correct. Good job, everyone. Competency 4 or 5 discussion is now complete. Explore state and local alcohol-related laws, ordinances, and regulations. The information presented in this discussion will be expanded upon with multiple learner interactive video experiences, where experts working in the industry will share their wealth of knowledge. Close the window and return to the web page and complete the next step.